Good morning and welcome to our panel presentation at this year's WCI seminar. My name is Neal Pitts and I'm a judge of compensation claims in the Orlando district. I am privileged to moderate a distinguished panel of 3 judges of compensation claims that are located throughout Florida. Our topic today is going to be on litigation trends. Let me introduce to you all Judge Iliana Forte. Judge Forte graduated from the University of Miami School of Law in 1990 and immediately began her career practicing workers' compensation law with the law offices of Alameda and Hill. A few years later, she became a partner in the firm. From 1997 to 2007, Judge Forte established the law offices of Iliana Forte, PA, where she continued to represent employers and carriers throughout the state. Her practice also involved representing injured workers, real estate, transaction, and general litigation. In 2007, Judge Forte joined the city of Miami as an assistant city attorney, where she represented the city in the defense of workers' compensation, labor and employment, and tort claims. She participated in arbitrations, hearings before the Public Employees Relation Commission, and state and federal court proceedings. In addition, Judge Forte has handled dozens of appeals and has argued before the First and the Third District Courts of Appeal. She is also a member of the United States District Court, Southern District of Florida, and the United States Court of Appeals for the 11th Circuit. Judge Rob Arthur, who is a judge in the Lakeland District, graduated with a Bachelor of Arts, summa cum laude, from Indiana University in Pennsylvania in 1989. He was then awarded a scholarship and attended law school at Case Western Reserve University, where he was selected to participate in a student exchange program through the Canada-US Law Institute and studied for a semester at the University of Western Ontario School of Law. On graduation from law school in 1992, Judge Arthur moved to Florida, where he began practice in a multi-state law firm representing claimants in Social Security disability matters. He quickly transitioned his practice to the representation of claimants and employer carriers in workers' compensation matters. Judge Arthur worked for both small and large firms before becoming a state mediator in the St. Pete District of the Office of Judge of Compensation Claims in 2005. After 7 years in St. Petersburg, he took up the dual role of mediating in both St. Petersburg and the Lakeland District offices until being appointed as a judge of compensation claims by Governor Rick Scott in May of 2017. Judge Tom Sculco was appointed judge of compensation claims by Governor Bush in March of 2005, and he is in the Orlando District, is one of the fellow judges that I serve with. Before he became a judge of compensation claims, he was an in-house defense counsel for the Hartford in Lake Mary, Florida. And before that, he practiced workers' compensation defense for the law firm of Zimmerman, Kaiser, and Sutcliffe in Orlando. He earned an AB degree in political science from Brown University in 1990 and graduated with high honors from Boston College Law School in 1993. Judge Sculco co-authored Chapter 6, Workers' Compensation Appellate Practice and Procedures of the Florida Bar's Workers' Compensation Practice Guide, and he has lectured at seminars on workers' compensation issues. He is the chairman of the Orange County Bar Association's Workers' Compensation Committee and is an adjunct professor at the Florida A&M School of Law in Orlando. He currently serves on the Florida Bar's Workers' Compensation Board Certification Committee, and before that served on the Bar's Workers' Compensation Rules Committee. He is board certified in both appellate practice and workers' compensation law. So our topic this morning is litigation trends. And one of the hot issues in litigated issues in litigation is the affirmative defense of misrepresentation. This defense and the law surrounding it seems to provoke a lot of appellate decisions and litigation over exactly what it means. So I'm going to ask Judge Forte if she will take the lead on this topic and present it. Thank you.
Thank you, Judge Pitts. So this all started back in 1998 when the legislature amended Section 440.094 to specifically allow judges of compensation claims to make misrepresentation determinations. While the statute provides that it applies to all accidents, regardless of the date of accident, the first DCA held in Rustic Lodge versus Escobar that the amendment was substantive legislation and it could not be retroactively applied. So judges of compensation claims, I find more frequently lately, are called upon to rule on misrepresentation, also known as the fraud defense, or what I call the nuclear defense option. It is the nuclear option because a finding of fraud forfeits all benefits for the claimant, but if the claimant overcomes the defense, the employer carrier is subject to the payment of attorney's fees, even if benefits by the claimant are denied. The statutory authority for the misrepresentation defense is found under Section 440, 105 4B1, which provides that it shall be unlawful for any person to make or cause to be made any false, fraudulent, incomplete, or misleading oral or written statement for the purpose of securing compensation. An employee who knowingly or intentionally violates Sections 440, 105 4B1 is not entitled to workers' compensation benefits per Section 440.094A. Section 440.094 states that an employee shall not be entitled to compensation benefits under this chapter if any judge of compensation claims determines that the employee has knowingly or intentionally engaged in any of the acts described in Section 440.105. An employer carrier may unilaterally terminate benefits under the fraud defense without having to wait for a judicial determination. But a judge of compensation claims lacks jurisdiction to rule on an employer carrier's fraud defense if a petition for benefits has not been filed. Currently, under Florida Administrative Code 60Q 6.1132, a fraud or misrepresentation defense must be raised in the pretrial stipulation with specificity, detailing the exact conduct giving rise to the defense so that there are no surprises. To establish the defense, the employer carrier must prove violation of Section 440.105 by a preponderance of the evidence. Whether a claimant has violated one of the provisions of Section 440.105 is a factual determination to be made by the judge of compensation claims. So a determination of fraud requires a two-part inquiry. A JCC must determine whether a false, fraudulent, or misleading statement was made by the claimant and whether the statement was made with the intent to obtain benefits. So the crucial issue is intent. The first DCA affirmed a JCC's ruling that rejected a misrepresentation defense in the case of Steel Dynamics versus Markham, even though the claimant made inconsistent statements in his deposition and the trial testimony. The court held that the ultimate question that a judge of compensation claims must answer is intent, and that is whether the claimant subjectively believed or intended the statement when made to be false, and whether the claimant subjectively believed that the statement would assist him or her in securing benefits. The court went on to state that a claimant's state of mind is an issue of fact to be determined by the judge of compensation claims by evaluating the evidence, including the credibility and demeanor of the witness. But it is not axiomatic that providing false information following a compensable accident will disqualify a claimant from receiving benefit. The court reiterated that generally, opinion testimony is not actionable as a misrepresentation because it involves opinions and not facts. So it is important to note that a claimant may lack credibility, which can be established through cross-examination, which is part of our litigation tactics or strategies, impeachment, and there may be proof presented that facts are not exactly as the individual testified, but the lack of credibility may not give rise to the level of fraudulent intent. And the standard of review for these cases is competent substantial evidence. And that is evidence that is not based on uncertainty, speculation, or conjecture. So a claimant may be a poor historian, a claimant may give false information to keep their jobs, they may have opinion testimony, which may not rise to the level of fraudulent intent. So I think it's important before the nuclear option is used that the case be analyzed and the statement, whether oral or written, be scrutinized to make sure that you can convince the judge of compensation claims that the claimant had a fraudulent intent when they made that statement, because not all statements are fraudulent.
And since this is a panel dealing with litigation trends, have you noticed an increase or decrease of the volume of the defenses being raised by the employer carriers on misrepresentation, or is there a particular area that they may seem to be focusing on? Judge Forte.
Oh yeah, I have definitely seen a trend, and I think, and why we wanted to really discuss this topic is that not every statement that can be considered a false statement is going to rise to that level, but I see that maybe inconsistencies are being considered fraudulent and in a case, or lack of credibility of the claimant. But I always put in my orders that this defense is not one that is taken lightly. So I think a judge is really going to scrutinize the intent of the person, and stating certain things that are inconsistent may not give rise to that level of scrutiny when the claimant's benefits are all at risk.
So, Judge Arthur, are you seeing any increase in your district? I know you're a heavily litigated district in Lakeland. You have a lot of trial orders. Are you seeing changes in trends with regarding to the defenses involving representation?
Ironically, the trend that I think I'm seeing the most is that carriers are afraid to raise the misrepresentation defense, and then they're coming in 30 days before trial, sort of with a change of litigation strategy and trying to raise the misrepresentation defense. Now, that's acceptable if the misrepresentation occurred at that time, but the cases I'm seeing is sort of, the carrier was on notice before the pretrial was filed of whatever event or statement that they claim gives rise to the misrepresentation defense, and they're just holding off. And I think, I speculate that the reason for that is they're afraid of having to pay the attorney's fees if it fails. But I've had, I think, 2 or 3 of those recently where I've stricken those defenses because they were not timely filed. So that, as far as the misrepresentation defense, that's the trend that I'm seeing more recently. But I think in general, where I see the misrep fail is for one of 2 reasons. Number one, the person didn't really say what the employer carrier thinks they said when you study with close scrutiny what their deposition testimony is or what exactly they told the doctor. And the other one is Judge Forte kind of touched on is the opinion. And I think there's case law out there. It may be the Markham case, but there's case law out there that says if you ask a claimant if they could lift 20 pounds or if they could walk a mile, that's their opinion. It's really a speculative testimony, and that's not a fact. Like, you can ask them, have you walked a mile? You can ask them, have you lifted 20 pounds? And if you have some evidence to the contrary, you have yourself a misrepresentation defense. I've had a number of these cases where, there's this speculative questioning. Can you do this? Could you do that? And then later there's some evidence, be it video or whatever it may be, showing activity inconsistent with that testimony, and a fraud defense is raised. I just don't think that gets it, because I think it's a speculative opinion if the claimant, even on his own merit, could or could not walk or lift or whatever the offending behavior is. So for me, those are the 2 places where I think that the defense fails mostly.
All right, and Judge Sculco in Orlando, what trends are you seeing in the area of misrepresentation?
Well, I'm not certain that there's any particular trend. I mean, I see certainly the misrepresentation defense is raised with some frequency. Sometimes it fails, and sometimes it's valid. It really depends on the case. I do want to jump in to say I really agree with Judge Forte in her point about intent being the essential part about misrepresentation. And I think if there's a practice tip I could give, if you're on both sides, but I guess particularly on the employer carrier side, if you're raising this issue, they often seem to ignore putting forth a coherent theory of the claimant's state of mind. They simply put forth the statement and they think that's sufficient, and that's often not sufficient. But the thing about intent is it's very rare that you're going to get a claimant to admit that they intentionally lied at a final hearing. That's only happened once since as a judge. It happened one time. It was sort of a Perry Mason moment in a case, but that doesn't happen very often. And we know from criminal law that intent, the jails are filled with people who don't agree that they possess the specific intent necessary for their crimes. Intent can be and often is inferred from circumstantial evidence. And I think that's really where both sides should focus. How does the theory of the case of the fraud fit with the circumstantial evidence in the case? For example, if you treated, if say a claimant treated with a particular doctor, 3 years ago, and then was sent to that same doctor after a work injury, and the allegation is that they didn't give the full history. Well, that doesn't make a lot of sense, because in that circumstance. So you just have to look at the circumstantial evidence. I wish people would focus on that more. So
because the employer carrier bears the burden of proof in this, as judges of compensation claims, do you carefully consider the evidence in terms of, because of the gravity of the defense, is this something that weighs heavily on a judge's mind before you're going to make the ruling and find there's been a misrepresentation that results in total denial of benefits? Judge Forte?
Absolutely. I mean, I think, again, this is the nuclear option. For both sides, it has consequences, serious consequences. Claimants loses all the benefits. Employer carrier would be responsible for the fees. So I think this is probably one of the most consequential defenses we have to hear and rule on. And so I take it very serious, and I really consider both sides and what they're saying. And sometimes it's easy. Sometimes the fraud is, it's clear that there's fraud, but sometimes it's not so easy. And those are obviously the cases that become more difficult to rule on and decide. Although, I was just thinking, I'm not aware, and I don't know if the other panelists are, whether a judge has been ever reversed for finding fraud. I know that judges have been reversed for not finding fraud, but I'm not sure that, and I know I'd have a case up there right now, but I'm wondering, I don't think I've ever seen that.
That's a good observation. Judge Arthur?
I'm not aware of it, but I haven't really done any sort of study on that as well. But to kind of get to your question, it just seems like the nature of the defense demands more scrutiny than other defenses possibly. A lot of times it may come down to, a few seconds on a videotape, or it may come down to 1 or 2 lines in a deposition, or 1 or 2 lines in a doctor's report, and comparing and contrasting things that are said in various places. So, would I say, do I give it more scrutiny? I just think it sort of demands it, because it's a fine line defense. There's not, it's usually, as Judge Forte pointed out, it's not real. Usually, if we're sitting here in front of us in a hearing, it's a close call, because if it's obvious, it doesn't make it to us. So yeah, I would say I do give it more scrutiny, just because I think it's required, to really pay attention to exactly what was said, exactly what occurred. And so I just don't think you can make a determination one way or the other without really, kind of drilling down on it.
And Judge Sculco?
Well, I will say that, of course, I would give it a great scrutiny, as I give all matters that come in front of me. But it doesn't bear any higher burden of proof than any other matter. And I think that's a mistake maybe that sometimes claimants attorneys take, is there really isn't a higher burden of proof. I mean, it's really, is it more likely than not? Is it 50.5% more likely or not? that the claimant made a knowing or intentional misrepresentation. I do think Judge Arthur has a great point, though, that because it's one of the few areas that involve assessment of state of mind we don't have too many areas like that. The misconduct is another one, I believe, where we have to assess state of mind, perhaps, of the claimant. But that does require a different sort of kind of analysis than other decisions do. But I certainly don't, to the extent that I would hesitate to do it or not, I don't agree with that. I think it's a preponderance of the evidence test, and whatever the evidence shows, I have to go with. That's what the legislature, that's our job as judges, to follow what the legislature said.
Thank you. So let's move into the topic of summary judgments and motions to dismiss, when to use and what to attach, the difference between the two motions, in the effect of the or not of the proposed amendments to change to the federal statute, the federal standard under the federal rules of evidence. So Judge Sculco, I'm going to ask you to lead off on this topic.
Thank you, Judge Pitts. There's really a couple of things I really would like to touch on. There's probably a lot of areas we could discuss. Certainly the specific question as to what to use or what to attach, that's right there in the rule. It's pleadings, affidavits, and sworn test and deposition and other sworn testimony. But an interest, we've had this discussion many times about motions to dismiss versus motions for summary final order. A motion to dismiss under the civil case law, there's no evidence taken at that hearing. The determination has to be made based on the four corners of the pleading, and there's case law interpreting even our motions to dismiss, not just in civil case law, saying that. But it leads to a conundrum that we've discussed many times, and I'm not sure what the right answer is we have motions to dismiss for lack of specificity in our statute under 440.192. 440.192, it requires that a medical report be attached that's recommending particular treatment if the claimant is under the care of a physician for an injury identified in the claimant's petition. Well, that's a factual precondition that often the parties don't agree on as to whether the claimant is under the care of a physician per that statute. So that leads to a conundrum as to how do we deal with that as judges? Do we hold some sort of evidentiary hearing on that factual underlying issue? Or do we simply say that if the parties don't agree that motion to dismiss is not appropriate under the case law? That's a very, I'm not sure I've ever come to a satisfactory answer on that, but that is certainly a conundrum that we deal with. In terms of summary final orders, there has been a very big development recently that I think we need to talk about. And that is that the Florida Supreme Court on December 31st of 2020 changed in re amendments to Florida Rules Civil Procedure 1.510, has indicated that they are changing Florida to the federal standard for granting of summary judgment. Before I get to the actual difference, of course, the big question for us in the workers' compensation world is, does that apply to us? At first glance, you might think, well, that doesn't apply to us because we know from a case law from the Florida Supreme Court that rules enacted by the Florida Supreme Court don't apply to executive branch agencies. But once you start looking at the details of it in the case law, I think it becomes a closer question. For once, the case that adopted the Florida summary the civil summary judgment standard in workers' compensation cases. The first one that I could see that specifically indicated they were adopting it was Thomas v. Eckerd Drugs, 987 Southern 2nd, 1262. That's a 2008 first DCA case. And it was just what they said was quite simple in the case. In the absence of case law offering guidance regarding summary final orders, we evaluate the JCC's order using the summary judgment standard. They didn't really give any further explanation for why they were doing that. I think the answer to that question is probably in the case law where the courts did this with the definition of misconduct in unemployment cases. They simply, we had a very similar written statute, and the court said we've got a whole body of law that's already addressed this in unemployment compensation, so we're just going to adopt that case law as befitting the standard. I think that's probably similar to what we had here. So once you understand that's the rationale for why we are applying the civil summary judgment standard to our cases, is that we've got a body of case law that's with a similarly written rule, it becomes a much more interesting question, because the Supreme Court, in their decision, they didn't actually change any of the language of the summary judgment, the actual summary judgment rule itself. All they did was they added to the part subsection C of Rule 1.510 a statement at the end which said the summary judgment standard provided for in this rule shall be construed and applied in accordance with the federal summary judgment standard articulated in Celotex Corp v. Catret and some other cases. So if the language of the rule hasn't really been changed in terms of what we're looking for, then certainly an argument can be made that for the same reason that the first DCA applied the civil standard to our cases, for the same reason they would now apply that same standard, the new standard, to our cases. But it certainly hasn't been decided, and that's just an interesting question, and I just thought I'd throw that out there. And so let's talk about what assuming that it may apply to us, what practical effect would that have for practice tips or whatnot? Well, there's a few differences between the federal summary judgment standard and the one that's historically been used in Florida. One of them doesn't really matter for our situation, which is that Florida courts have failed to recognize a fundamental similarity between a motion for directed verdict and a motion for summary judgment. That doesn't really apply to our circumstances. But the second one is very interesting, which is Florida summary judgment standard requires the movant not only to prove conclusively elements on which they bear the burden of proof, but also to disprove the non-movant's theory of the case. The federal standard does not. The federal standard only requires the movant to conclusively establish the elements on which they bear the burden of proof. An example of this would be, say, statute of limitations. The EC bears the burden in the statute of limitations of only a couple of things, showing that when the accident was, when the last benefits were provided, and that it's either 2 years from the accident or 1 year from the last provision of benefits. That's all they need to establish in their motion for summary judgment under the federal standard. They don't need to disprove estoppel, which is under the current Florida standard. They would have to literally disprove every possible avenue of escape for the claimant, whereas under the federal standard they wouldn't. So to me, that's a very important practice point. We don't know whether it's going to end up applying or not, but if you're responding to a motion for summary judgment I think anyone would be very well served to do more than just create a paper dispute and actually put forth affirmative evidence establishing elements on which they bear the burden of proof. And the other, I'm sorry, one last important difference is that the Florida standard only requires a scintilla of evidence to defeat a motion for summary judgment. It doesn't have to be credible. It doesn't have to be reasonable. It just has to be any evidence at all is essentially sufficient. The federal standard requires it be much more persuasive, that it could persuade a reasonable judge or jury. So that places an additional burden on responding to motions for summary judgment to put forth not just a scintilla of evidence, but actually enough evidence that could actually persuade a reasonable jury. Judge Pitts, I saw you had a question.
Well, I was going to just say, for the benefit of the audience, is the wording of the summary judgments standard under Florida rules of procedure, under the Florida rules of procedure and under our Q rules, essentially the same.
Yes, that's why the first district, I believe, adopted the summary judgment standards, because we had an essentially similarly written rule, and there's a whole body of case law that addresses that.
And then the wording of the Florida statute and the federal statute, is it essentially the same?
Well, yeah. Well, I think that there was they didn't make any wording changes at all in the Florida Supreme Court. They simply said that, I think they said, we don't really like the way the Florida courts have interpreted these words. We're telling you to interpret them differently now, I guess.
Okay, so Judge Forte, would you like to add to this discussion in terms of motions to dismiss or motion for summary judgment, the trends that you're seeing in this area, or even lend a hand to us on this federal standard change?
Well, it's the issue usually is, are there issues of material fact that prevent me from granting this motion? And I usually find that they probably are. It's very sparingly where I find that there isn't an issue on the other side that's disputing a factual issue. Obviously a legal issue, then I can make that determination. I don't know that we have to get so specific with regards to what this rule provides or that. It seems like it either is or isn't. So there are going to be issues of material fact or they're not. And I tend to err on the side of there usually are issues of material fact. So I grant them very sparingly.
Thank you, Judge Arthur.
The trend that I've been seeing lately, as far as both of these go, kind of fall in two categories. I'm getting sometimes motions to dismiss and sometimes motions for summary final order on the basis of the claimant did not make a good faith effort to resolve the dispute before the petition was filed. And I've been seeing a lot of those. And, I really don't take a lot of care as to whether it's a summary judgment or a motion to dismiss, because I think they fail both ways. So it doesn't matter to me. I think it fails as a motion for summary judgment because, as Judge Forte was putting out, I have an affidavit from an adjuster saying no one ever called me before they filed this petition. But I also have evidence in the form of the petition and the certificate attached to it saying that I did. So right there, you have a conflict in the evidence. So it's not appropriate for summary final order. And as far as a motion to dismiss goes, there's case law right on point that says if that claimant or attorney signed that statement, then for purposes of a motion to dismiss, you have to accept that as true. And so now I had a case where I made such a ruling, but the carrier was smart enough to maintain that defense through to the final hearing, and the claimant's attorney wasn't smart enough to do anything about it. So in the end of the day, I didn't dismiss the petition, but I ruled in favor of the employer carrier because there was no evidence that a good faith effort was made before filing the petition. So I dismissed it at the time of the hearing. So that's one of the trends I'm seeing. The other trend I'm seeing in motions for summary final order in particular is I'm seeing these cases, particularly where you have multiple employers, usually like on a construction site. And I get one of the employers files a motion for summary final order and attach that as an affidavit that says he didn't work for me. And, this is maybe a month after the petition is filed. Well, I think the wording that the facts have to be crystallized doesn't mean the facts at the moment the the motion is filed. It's the facts in the case overall have to be crystallized. And I've had a few hearings on these cases, and I've said to the attorney, I said, well, what does the claimant say? What is this? We've got 4 employers here. What do they all have to say? And the answer is always the same. Well, I don't know. Their depositions are set. So, I don't know what their testimony is going to be. Well, I don't think you have crystallized facts if you don't even have what the facts are. And so I've been seeing a lot of those, and maybe in the end of the day, that motion is appropriate, but I'm finding that they're filed like way too prematurely before there's any real development of the facts in the case.
Well, before we leave the topic, it was interesting to me as preparing for this panel discussion is whether judges across the state will grant partial summary judgments, as you can get under the civil procedure rules and federal rules, or whether they require summary judgments only to be entered in cases where it disposes of the entire petition for benefits. Judge Forte, let me start with you. And what is the practice in South Florida, particularly you and maybe other judges in that regard?
Well, I think I can only speak for myself. I don't really know what other judges tend to do with those. But I have granted partial summary judgments where it doesn't resolve the entire claims on the petitions. And I think I pretty much have ruled only on cases where managed care is the issue and the grievance procedure hasn't been exhausted. So I don't have jurisdiction over the medical claims. And so I have no jurisdiction. I think that I felt comfortable ruling in favor of the employer carrier in that case. A lot of times I don't even get a response from the other side because they know they didn't go through the grievance procedure. So nobody's even objecting to that motion for summary final order where they have 30 days to respond. So I don't hesitate in granting those, but I don't feel, I haven't had any issues with it. Let's just put it that way. Nobody's appealed that. So I have granted them in partial manner.
Thank you, Judge Arthur.
It's interesting because I do not see motions for summary final order on the grievance issue in particular. I always see those as motions to dismiss, and I always set them for an evidentiary hearing. And I don't know why people file them that way, because many times they're filed as with attachments, but they're filing as motions to dismiss. But yeah, I've also seen that in most of those cases there is no response, and a few of them there are responses, and those are the ones where there's clearly here's the grievance, here they have everything lined up and they do respond. But I think for the most part I'm seeing the same thing Judge Forte is saying, is that there's really no response to that, because they haven't done anything.
All right. Judge Sculco.
Well, your question is a very interesting question because the rule 60Q-6.1201 says the judge may enter a summary final order when such an order would be dispositive of the issues raised by the subject petition. I haven't had this come up only a couple of times, but to me, the ordinary grammatical meaning of the issues raised, dispositive of the issues raised by the subject petition, is it would dispose of all the issues. So based on my sort of using ordinary grammar, I say that you can't do partial summary final order because of the way the rule is written. But I certainly see, you could make an argument perhaps that dispositive of the issues, maybe they're not referring to all the issues, maybe just the issues that are, maybe just some of the issues. It's not entirely clear, but I just think the better grammatical reading of that sentence is the means all. But so the one time I had it, I refused to grant summary final order because it wouldn't have been dispositive of the entire petition.
But the difficulty with that is that you'd only have a couple of cases where you would be able to grant summary final order. So the only place that would apply would be, like you mentioned before, statute of limitations. If it wouldn't dispose of the entire case, then you'd probably have very few circumstances where you'd be able to grant a summary final order. And maybe the rule then would be not necessarily very effective.
It's a very interesting area. And it is a conundrum that I haven't seen that the First District Court of Appeal rule on definitively, and we probably could talk a lot about this, but let me move on to the next topic. Not because I don't find that one fascinating, but because Judge Arthur has prepared to talk to us about the trend in motions to strike physicians and EMA testimonies. I know I'm seeing them in Orlando, and I'm sure you all are seeing them throughout the area. So, Judge Arthur, what are you seeing in regards to these particular tactics?
So I'm seeing it based upon really primarily three bases. And to go over quickly, the first one I'm seeing is based upon the doctor charging too much for the deposition. The other one is the doctor charging too much for the treatment. And then the last one I'm seeing is a Dauber objections. And, as far as the charging too much for deposition and too much for treatment, I've seen a few of those cases. The problem is with those motions is 440.13.10 clearly establishes the doctors cannot charge more than $200 an hour to provide their testimony. But that's it. Like, it doesn't say, well, what if they do? So I don't know of any authority anywhere that says, well, if they do, then it is automatically excluded or the JCC can't consider it. That I've never come across that case law, and I've not seen it. So when I'm seeing those motions, I'm just not sure what to do with them, because I've had a few of these cases. The doctor was clearly charging more than the $200 an hour, but there's no remedy for that. At least I feel that I have, without some sort of other authority, statute, rule, or case law. And I'm not aware of any, and nobody's been able to provide any to me in the motions that I've had. Very similar, but slightly different than that is under 440.13 subsection 13B. It basically says, summary, you have to charge the fee schedule. For a treating doctor, you have to charge the fee schedule. And I've had, a couple of these cases where the doctors have charged more than the fee schedule. The statute contains an out, so that as long as there is an agreement between the carrier and the doctor that the doctor will provide sort of enhanced care, I'll use the phrase, then they can agree to pay him more. And the statute outlines a few things that are advanced care, like he's giving it to him at a reasonable cost. He's going to get appointments quicker. He's going to engage in return to work programs. Like, there's certain things that are outlined in the statute as to what should be contained in this agreement. So I've had two different types of cases. One where the doctor was charging in excess of the fee schedule and there was no agreement. And the other was there was an agreement, but it was challenged that it didn't meet with the parameters of the statute. Now, any of the ones I've had regarding the parameters of the statute, I've always found that the agreement was within those parameters, because it is fairly loosely defined and it's pretty much all encompassing. But the interesting question on this subsection of the statute is the same as on the previous subsection of the statute. It doesn't really say what happens if they're charging more. The only difference is, and I've had this argued to me several times, is there's sort of, there is case law on the topic of what do you do if a doctor charges too much. And there's an old case from 2001 called Riviera Beach versus Napier. And that actually dealt with a subsection of the statute back in the 90s that limited how much an IME could charge for his services. And in the case, one of the parties obtained an IME, the IME charged in excess of the statute. So the reasoning of the district court on that case was an IME is only allowed to charge $1,000 or whatever the cost was. They can only charge $1,000. This doctor charged more than $1,000. Therefore, he's not an IME. And under the statute, only an IME, treating physician, and EMA can provide opinions in a case. And so I'm getting that case argued of, there's no difference here. And the logic still applies. And that is, hey, you charge too much. You are not an authorized treating doctor without this agreement. and Napier says, if you charge too much, you're not an appropriate doctor, and you get excluded. So those are, under those two, that's what I'm seeing on those cases. I'm also seeing a lot of Dauber challenges, and I think there's somewhat of a misconception as to what Dauber really is. I think probably most of the cases I'm seeing on Dauber are just, well, the treating doctor and the one-time change and the carrier IME all say X, and the claimant's IME says Y, so therefore the claimant's IME must be excluded under Dauber. But that's not the standard. The standard's pretty simple, is the opinions have to be based upon sufficient facts or data. The testimony has to be the product of reliable principles and methods, and the witness has to apply the principles and methods reliably to the facts of the case. I think for the most part, what we're seeing on medical testimony, it's pretty simple. The facts of the case are the prior treatment notes, the diagnostic, the history from the claimant. The method is the doctor takes all that into account, looks at the claimant's history, the history of the case, looks at the diagnostics, and then they render their opinion encompassing all of those factors. That's the accepted principles in the medical profession. And I think if the doctor is applying those principles and has the facts, then it doesn't meet a Dauber challenge. Now, there are exceptions to that, because I've had a few cases where there was an IME and the IME was not presented with half of the medical records that were necessary. But that's sort of the exception rather than the rule. So as far as the three trends that I'm seeing in motions to strike, that's what I'm seeing here.
And Judge Forte, down in Fort Lauderdale, where you sit, what trends are you seeing in this area?
Well, I've gotten motions to strike EMAs, but I think we know from the case law that just because the doctor doesn't answer exactly the question that was asked, or maybe didn't review exactly all the medical records that you wanted them to focus on, doesn't mean that they get stricken. It pretty much means that you're going to not use them as the actual, their opinion as being the convincing evidence, but they still can testify as an expert witness. So I haven't granted those, but I've seen those come through. And the ones that Judge Arthur was referring to with regards to the carriers paying more for the doctor's visit than the statutory fee, I have seen where they've come in and tried to strike the doctor because they're getting paid above the stat fee. And again, I think as Judge Arthur mentioned, there is no prohibition in that, but you are required to have some type of written agreement. And where I've seen is that there is no written agreement. The carriers agree to pay more because they need that expert, because maybe they can't find anybody else and the doctor isn't willing to do it at the statutory fee amount, but there's no agreement. So it makes it very difficult for me not to strike the witness if there isn't an agreement as to why they're being paid. So I think that, the safest way is please have the agreement so that you can get the doctor treatment, because the flip side of that is if the carrier refuses to pay above a stat fee, there's nothing judges of compensations can do. And that may prevent the claimant from getting the treatment that they need. And, that goes back to the case of Marine Max versus Blair, where the court said judges don't have the jurisdiction to have a carrier pay above the fee schedule, even if it's a doctor the claimant wants and it's been seen for years. So, it's a kind of situation that can be difficult for both sides.
Judge Sculco, what trends are you seeing here in Orlando with regards to these issues?
Well, certainly seeing a lot of Dauber challenges to expert testimony. I think that the one issue I'm seeing most with the Dauber challenges is issues of preservation. The Booker case, which is what I think maybe the second case that came out of the first district dealing with Dauber in workers' compensation cases, gave a pretty detailed explanation of what's required to preserve a Dauber challenge. And there has to be a timely, specific objection made to any specific opinion. Dauber doesn't apply to testimony as a whole, it applies to opinions. And oftentimes the objection isn't specifically directed to a specific opinion, which makes it really, I think doesn't even get get past first base at that point, that kind of objection. So I think people should pay a lot of close attention to the preservation of requirements of Booker to make sure they're preserved their Dauber objection. The motions to strike the doctors for paying above the statutory guidelines. I believe that Napier case, I think I was the attorney for the EC on that case. I think that was a Hartford case, if I remember correctly. That one didn't go well for me, if I remember right. But in terms, the one thing that I am seeing some on that issue is doctors, the statute says you can't charge more than $200 an hour for deposition testimony, but it says nothing about preparation time or records review or other things. And I think doctors' offices are now figuring this out and are arranging their bills so that the actual deposition testimony is $200 an hour, but there's all these other charges for other items as well. So it's not really clear how the statute addresses that situation.
Well, moving to another worthy topic, if based on the recent edition of the 440 Reporter, which is heavily focused on professionalism, and with the advent of the ends of the court movement throughout the state of Florida, there's a lot of emphasis in our area of the law practice on professionalism. And that really involves communication between parties, which is required by Rule 6Q 6.115. Lawyers are supposed to communicate with each other before filing motions. Now that is somewhat aspirational, it appears, in practice. Judge Arthur, what are you seeing in regards to in your district with the compliance with this rules or problems that you're having with them?
The problem that I'm having, and sometimes it's just right in your face apparent, is, a motion is filed and it said, we, used a good faith effort to confer. And we sent an email to the opposing attorney and we didn't hear a response. And, you hate to go behind an officer of the court who's making an assertion, but some of these attorneys actually will attach the email that they sent. And what seems to be the case more times than not is the email is dated and timed February 1st at 9:57 a.m. and the motion is filed on February 1st at 10 a.m. So, I don't believe that's a good faith effort to confer with opposing party when you gave them 3 minutes to respond to your email. So those I just summarily reject. Now, the ones that don't attach, I'm always up in the air about what to do with that. And I have been contemplating a lot recently of, perhaps I should make people outline in their motion what efforts have been made. Some attorneys do that. We called on this day and this date, we emailed on that date, provided a copy of the motion on another date, and here we are a week later, so we're filing the motion. And I am debating whether I'm going to require that in every motion, because I've just had so many cases where, number one, the emails are attached and they show that it wasn't a good faith effort, or number two, the response comes in from the opposing party that says, oh yeah, they sent me an email at 9 o'clock and then they filed their motion at 10 o'clock. What am I supposed to do in an hour? So, I'm interested in what the other panel members do in those situations and what they're requiring in their motions. Clearly, people are not talking.
Yeah, that's exactly true. Judge Sculco, what are your comments on this?
Well, I agree with Judge Arthur. I think I think I'm seeing the exact same thing. In my view, the level of personally conferring is very, very light, I would say. I know in federal courts, they have a personally confer requirement that literally doesn't matter how many times you try. If you don't actually personally confer, you can't, the judge will dismiss your motion and the judge may have a status conference and order you to have lunch with the opposing counsel and things of that nature. I don't know that we'll ever quite get that far, but certainly I think personally conferring should mean at least getting on the phone and trying to talk to someone. I'm not a big fan of the email. Although the way our rule is written, it does seem to permit an email conferring, which I don't like, but I didn't write the rules, so I just have to follow the rules.
That's the truth. So, Judge Forte.
Well, typically when the parties confer, I usually get a motion that says unopposed, and they both talk to each other, they both agree. So that's usually what I know the parties have conferred. The other times it's very difficult to make that determination. I really go by face value, what they put there, that they've tried, they attempted to, and they weren't able to get a hold of the other person, or they actually will say the other party opposes the motion, and then they have 15 days to respond. If they don't respond, I may grant it if there's a valid request. But I really just take the party's word for it, and they're all members of the Florida bar. They need to do what they need to do, and I don't find that I need to police every motion to confer. Now, clearly, if they don't put anything there, I summarily deny the motion.
If the certification is not there, you summarily deny the motion.
Correct. Which is what the rules provide.
Absolutely. Yeah. So in the couple of minutes that we have left, we have the issue of uninsured, unrepresented employers. And Judge Sculco, I know that you and I have talked about this with regards to whether an uninsured incorporated employer can represent themselves in a proceeding, or must they use an attorney? And so I'm interested in your comments on that.
Well, that's a fascinating topic that we have discussed. I don't know that I could cover it all in 2 minutes, but I'll try to. The big case that deals with the unlicensed practice of law before an executive branch agency is the Florida Bar v. Moses. To jump to the points of the case, but to try to move it along, Moses held that it's certainly arguing in front of an administrative agency, presenting evidence, that is the practice of law. That is typically requires an attorney to do it, but that the legislature can authorize non-lawyer representation before administrative or executive branch agencies. So the question is, does our statute authorize non-lawyer representation of corporations? And it's interesting. I think arguably it does. 440-25, that up, provides that at the final hearing, this is 440-25 4D, says at the final hearing, the claimant and the employer may each present evidence with respect to the claims presented by the petition and may be represented by an attorney authorized in writing for such purpose. So if they may, that also means almost by implication that they may not, or else they would say they must. So arguably that statute authorizes a corporation employer to represent itself. There's an interesting, although I know some judges have come to an opposite conclusion, and I'm not certain that that's the right answer, but it does seem as though there's at least some possible statutory authorization in 440-25 for that. So what, in our few seconds left, let's ask our other panelists what they think.
Judge Arthur, have you been confronted with this issue? And if so, how have you handled it?
I'm always willing to admit when I'm wrong or maybe wrong, and I've always ruled in the past that a corporation could not represent itself. But I have, and recently in looking into this a little further and delving into the statutes a little further in other case law, I'm not sure that I would rule the same way again when presented with it, because I think there may be, I guess, an exception to that, because I don't think there's any specific case law as to whether they can do it in a workers' compensation case. There's certainly first district court cases that say they can't do it in a circuit or a county court. So I definitely will take a harder look at it the next time I'm presented with it. But in the past, I've always said that they could not, but now I'm not so sure.
And Judge Forte, what has been your experience with this or your practice?
Well, I have, it's come before me a few times. I can say that at no time has the uninsured employer prevailed before me, but I have allowed them to say their piece, to tell me their side of the story. Very few times, if any, I don't recall that they've introduced anything into evidence. They just come in and say, well, he never worked for me, or he, they'll tell me their story, but typically I don't find it to be so prejudicial not to allow it, to say simply, no, you're not allowed to testify, you're not allowed to do anything. So I maybe erred on the other side and have allowed it.
And so since it is a topic on trends, have anyone noticed that there is an increase or a decrease in the number of unrepresented employers that are coming into your cases? I'll start with you, Judge Sculco.
I don't know that I've noticed any trend. I mean, occasionally I will run into an unrepresented employer. And, occasionally there'll be very occasionally there'll be a corporation, and then we'd have to struggle with this issue. But to Judge Forte's point, I will say that there's a difference between testifying and presenting evidence, and being a witness. Then that's not the practice of law. But the practice of law is examining witnesses, making legal arguments, doing things of that nature. So I think certainly there'd be no problem with any individual who works for a corporation coming in and testifying, no matter under any standard.
Judge Arthur?
Well, I have seen, I think, a big uptick in the number of unrepresented employers in cases, but I have not seen them coming before me. What I have seen them do is just not respond or do anything, which eventually results in my striking their defenses. And the cases, usually those cases are all proceeding against multiple employers under statutory employer theory. And so I think I have been seeing a lot more of them, but they're not participating. They're just ignoring the whole thing and hoping it goes away, which, I mean, I think usually for them, it does, because there's someone else in the chain of employers that ends up responsible.
So let me conclude with Judge Forte for the last comments on this.
I agree. I think by the time, that I haven't seen too many, because by the time they do come to trial, the defenses may have already been stricken. But definitely I agree with Judge Sculco that there's a difference between an employer coming and telling their story, but they typically, I haven't seen too many that are cross-examining any witness. They simply just don't know how to do it. So it doesn't usually get to that point.
Well, this concludes our time. I want to thank Judge Sculco, Judge Forte, and Judge Arthur for the time, effort that they've devoted to this. I have found it to be a fascinating seminar on the topics that we've been able to discuss. I wish we had more time. And I thank everyone for attending this seminar and listening to us. Thank you all very much.
Thank you.
Thank you.